Hello.
Kia ora. So my senior counsel Peter Gunn is here on the phone at the moment.
Okay.
And he's just to get in, so he's going to try it in another browser just like I did.
Yeah, we had a wee bit of trouble getting in too, but finally we got.
Can you hear Peter when he speaks?
Hi everybody. I'm not sure how clearly I'm coming across on the phone. Can you hear me?
Yes, it's very good.
Yes, clearly.
Okay. Brilliant. Are you still going to try another browser, Peter?
I am doing that as we speak.
Okay, brilliant.
I get guarantees of successful outcome, sadly.
If only I would be able to help you with the tech.
It's all new for us, isn't it?
Yeah.
The new system. We're the pioneers.
We are. Like that vision.
Yeah. I think it's quite good, don't you, that we can all meet like this?
Oh, it's fantastic. Otherwise, it would be very hard to meet.
And
I might be not a very good use of anybody's time, so my apologies for the fact that I'm not being able to hook into the meeting. And if people are happy enough for me just being on the phone, perhaps we could run it in that way and see how we get on at least. Are people happy to proceed along those lines?
Sure.
Yeah.
And I'm sorry, I'm saying people, and that's because I can't see anybody, and I'm assuming that there's more than just Bex on the call. Would people like to identify themselves? Don't have to, but if they would, I'd be happy to do that. My name's Peter Gunn, and I'm a lawyer with Crown Law.
Okay, we'll start with Diane, and then Sharon, and then Maxine, then Jodie, and then I'll go last if that's all right. Okay, where you go?
Yes.
Hi, Peter and Rebecca. My name is Diane Moore, and I'm just the note taker scriber for Kate, for the applicant, and I'm an observer as well.
Hello, Diane. Nice to meet you.
Kia ora, Peter. I'm Sharon Turner, and I'm the cultural advisor for the Sixtus.
Hi, Sharon.
Hello, Sharon.
Hi, Peter.
Hi, Peter. Hi, Rebecca. I'm Maxine, and I'm Kate's Mackenzie friend and observer.
Hello, Maxine.
Hi, Peter and Rebecca. I'm Jodie Uther. I'm personal assistant to Kate Floss and observer.
Thank you, Rebecca.
And I'm Catherine Sextus.
That was Jodie.
That was Jodie.
Oh, Jodie.
Oh, sorry.
I'm Catherine Sextus, and I'm the main applicant. Sometimes they call me Kate Floss, but anyway, I'm Catherine Sextus, and I'm hoping today that we can make. We didn't really understand what it is that you thought that our application was incomprehensible, and I'm hoping today to find out what it is, the problems that you had. But just before we do that, I'm just wondering, because I had promised for Sharon that she wanted to speak for a little bit about something, and I'm wondering if we can just hear her first before we get started. Would that be all right, Mr. Peter?
Yeah, look, yeah, call me Peter, that's fine. So you do what you need to do in that regard.
Okay, Sharon, we'll get you to say a little piece that you want to say.
Kia ora. As an adoptee of Her Majesty the Queen Victoria of England, I would like to refer to the Kohimarama Conference of Native Chiefs in part reference 3 Her Majesty extended to her native subjects her royal protections, engaging to defend New Zealand and the native subjects from all aggressions by foreign power. Part Reference 5. Her Majesty has instructed the governors who precede me, and she will instruct those that come after me, to maintain the stipulations of this treaty inviolate, and to watch over the interests and promote advancement of her subjects without distinction of race. Part Reference 6. Her Majesty's wish is that all her subjects should be happy, prosperous, and contented. Part Reference 13. It is a matter of solicitude to Her Majesty, as well as the many of our friends in England and this country, that we should be preserved as a people. No unfriendly feelings should be allowed to grow up between the two races. Part Reference 14. I believe it is only needful that these matters should be well understood to ensure a continuance of peace and friendly feeling between the two races of Her Majesty's subjects. In conjunction with 71 of the 1852 Constitution, asserting Queen Elizabeth's governance and protections over all New Zealand, I will be asking on behalf of natives of all New Zealand for a consolidation of 1865 1908 Native Rights Act.
Thank you very much, Sharon. That was just lovely, and so that is one of the main points of our case. Is well, we'll talk about it later, but I'll just reiterate what Sharon did say, is that we should be governed in New Zealand, but with no distinction of race by the Parliament. And part of our case is that Parliament is not upholding the agreements that were made in 1860 at the Commemorative Conference and several other agreements. The essence of our case is that we are asking for a declaration of right to reconsolidate. It was first done in 1844, and then again done in 1847, then again done in 1865, and then again done in 1908 as a consolidation where various groups of our peoples have entered the court and asked for a declaration of their right as subjects of Her Majesty the Queen, and to be placed under those protections, and for those protections to be upheld by all parliaments. So this is I have given, we've only got, I've been told that we have like maybe half an hour. I know you're very busy, but I have put the cause of Section 1, Section 2, cause for relief 1, cause for relief 2, cause for relief 3, cause for relief 4 of several anomalies in the laws that have been instituted in New Zealand since 1986 that seem to be repugnant to our 1688 imperial rights of the Will and Mary. And so I wanted to call the various ministers, specifically that I realised that Jacinda Ardern was not in power at the time that some of these laws were written, and I realised that Chris Farfui as the Justice Minister were not in power. However, they are the people that are in power today, and so they are the people that I need to call to ask these questions of. And so I thought that I made it very clear in cause 1, cause 2, cause 3, cause 4, the various questions that I have. I'm also, in regards to Andrew Little and the Minister of Health, we have asked for 4 declarations. There is quite the confusion about the human rights, the 1990 New Zealand Bill of Rights Act, the Tikanga Law, and the Declaration of Inconsistency, and among others as well. I'm just going to mention those ones today. But there are thousands of laws being placed into New Zealand domestic law, and the public have become extremely confused about, and they've got various groups running around New Zealand telling them that they're under this law or they're under that law, or you have to, and everybody is extremely confused. So we're going to be asking we hope the High Court to give us some clarity of a consistent law that we all as New Zealanders, all New Zealanders can follow and uphold. So that is the part one essence of our case. In the event that the court agrees that the 1688 Will and Mary is the supreme law and has I forgot my words, but anyway, is strictly upheld in New Zealand, then we'll be challenging. I'll be challenging that Jacinda Ardern and Chris excuse me. I just want to whip back there to Andrew Little and Ashley Bloomfield. We have questions in regard to S28 of the New Zealand Bill of Rights 1990 Act. S28 states that other rights are unaffected, and we're asking for the court for clarity if this refers to our 1688 Will and Mary Imperial Law of the 1988 Imperial Laws Act. And we are also asking that we are confused and distressed about the recent Yardley case.